No, I don't believe so.
All right, was he able to tender an offer?
No, not yet. So if I can get a plea deadline date perhaps for the next setting.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline.
I can do August 11th or August 14th.
14th, please.
Judges, I've been in communication with Mr. Sal, and he had relayed to me that quite already took every longer.
Oh,
I'll work
okay.
All right. All right, so August 14th is going to be your plea deadline date. So
August
that date,
14th, okay.
You need to let the court know whether you've reached an agreement. If you have not reached an agreement, your next court date is going to be a jury trial. Do you understand?
Yes.
All right, thank you for dressing appropriately for court.
Thank you, Judge. May she be excused?
Yes.
Okay, thank you.
Once she signs the
Yes,
reset
ma'am.
form.
Yes, ma'am. Yeah, I'll be right back. I'll meet you in the hall.
I know you're busy. Christina Lozano. I don't know. I still put the.
You don't want to do. No, that's just.
Man, isn't criminal law just so unpredictable? Every day is a new day, Judge.
It is. And you think you have your day set out for you. You're like, as a defense attorney, I always say, I'm going to go to this court first, get it in, do this. And then a client wouldn't show up and it throws off the entire day.
Whole thing, Judge. Whole thing.
But it's good seeing you, Hunter.
You too, Judge. Oh, no problem.
Yes. Yes, I have Rendon. We're not finished. No, they're doing the paperwork. Oh, that's what I need. Yes. All right, are the parties ready on Rendon?
Yes, yes.
All right, let me find his paperwork. All right, we're back on the record in 2024 CR 2339B, State versus Mariano Rendon. The defendant had entered a plea of no contest. State, are you offering State's Exhibits 1 and attachments?
Yes.
No objection?
No objection, Judge. We did look at them.
All right, and again, Mr. Rendon, you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Judge.
All right. With regards to restitution, it is my understanding that you do not wish to be present for a restitution hearing. Is that correct, Mr. Rendon?
Actually, Judge, I confused the court. That's on his other case that he's already been sentenced on, that had a post-conviction restitution hearing pending.
All right. What is the cause number for that case?
His cause number is 2024 CR 2338B.
All right. Mr. Rendon, in cause number 2024 CR 2338B, are you asking to waive your appearance for any restitution hearing in that cause number?
Yes, ma'am.
All right. And defense, have you spoken to your client about his waiver of the appearance at the restitution hearing?
Yes, Judge, and while we were off the record, I confirmed with counsel. It looks like they have a general idea what the number is going to be, and I've shared that with Mr. Rendon, so he definitely would like to waive his appearance.
Right. And in regards to the instant case, is there anything you wish to say on behalf of your client?
We just asked the court to follow the plea agreement, Judge.
All right, State, you may be excused. The court will sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 60 days. Well, I'm going to say proof of employment within 90 days of release because I know you'll be in custody. There's to be no employment as a home health care provider or with minors or in the bar industry. There's to be no contact with Oscar Del
Hero,
Fiero,
hero,
Fiero,
hero.
Fiero. There's to be anger management, TAP evaluation, 200 hours of community service restitution, 100 hours will be waived upon completion of anger management. Field visits 1 time per month for 8 months. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court to be successful?
No,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, Your Honor.
Oh, I'm so sorry. There's also an affirmative finding of deadly weapon. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. When you're released, we can go off the record. People always forget this. That is why when I was a defense attorney, I never liked for judges to have somebody go to prison, then you come back out and you're on probation. So you need to remember, when you're released from prison, you need to report to probation on the first business day of your release. You understand?
Yes, Your Honor.
If you don't do that, there's going to be a motion to revoke file.
Yes, Your Honor.
And probation will give you information on who you should contact. And if you don't remember, if I'm still here when you're released, come and check in here and they'll give you information, okay?
That's gonna be on the same day, correct, Your Honor?
Yes,
Okay. The day after you get out. Or the
Yeah.
day?
yes, just the next business day, okay?
Yes, Your Honor.
All right, good luck to you.
Yes, Your Honor.
Thank you. Who is here on Ativigan Leo?
You can right now. You can do a plea and have a court.
Norma,
Yes, ma'am.
no more cases. If it's gonna be, Norma,
Yes, ma'am.
if there are gonna be some kind of plea agreements, then I'll take those up at a break during trial, but everything else, it's gonna be recalled back for next week. Court is calling 2025 CR 0035001 State versus Ativigan Leo. Could I have parties announced?
Spearhead from the state, Your Honor.
David Andre Wood for Mr. Liao.
Are you Mr. Leo?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Leal, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
I'm sorry, Judge.
Are you proceeding on the
Yes,
state?
Your Honor.
Thank you.
Sorry.
No problem. Mr. Leal, did you review the waivers and admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering into this plea bargain agreement, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, was your client able to provide you with any defenses?
He was, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge.
Mr. Leal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State recommends community supervision and ignition interlock. Is that ignition interlock for full term?
I put it on there, Judge. Usually I recommend. So I don't want to.
All right. They're recommending for half the term. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
It is, Judge.
State is at the plea.
Yes, it is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that the community supervision be for a term of 7 years. There be 10 days in the Bear County Jail as a condition, 200 hours of community service restitution, and 2-year driver's license suspension. Did you understand that was recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State exhibit as well as all this.
No objections, Judge.
All right, state, you may be excused. Did you review the waiver and stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the recommendations, Judge.
All right. Are you currently employed?
Yes, ma'am.
What do you do?
I'm a quality engineering supervisor.
All right, this is what the court is going to do. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, ignition interlock for half the term, 10 years in prison, suspended and probated for 8 years. There's 200 hours of community service restitution. I'm going to order 90 sober meetings in 90 days. There's to be a TAP evaluation out of custody, a referral to felony drug court, DWI education course, VIP live, 2-year license suspension. All right, with regards to the Bear County Jail, you can either do 10 days in the Bear County Jail or 30 days on GPS. It will be partial for employment only.
30 days GPS, ma'am.
All right, there's to be 30 days GPS, partial for employment in lieu of 10 days Bear County Jail. For the record, the reason why the court is doing that, I don't want you to lose your employment, and also because there are health issues and overcrowding at the jail. There's to be a $2,000 fine. That will be probated. Probation, is there anything else? Thank you. Field visits 1 time per month for 6 months.
And Judge, at each gift, what day do you want it installed?
What's the soonest it can be installed?
I believe he currently has it in his vehicle, Judge.
A week, Judge?
No, the GPS.
Oh, GPS. I thought she said it.
Within a week? What date do you want probation?
The 17th, Judge?
All right, the GPS is to be installed within, by July 17th at 5 p.m. If that GPS is not installed, that's a violation of your conditions of probation. Do you understand?
Yes, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You're one of those people who can't drink alcohol. I have yet, in defense, I don't think you've ever had a client who said, my intention was to become intoxicated, hit somebody, pick up a DWI, or kill somebody. But that happens every day. And when you're out there driving, do you have children?
I have one daughter, Your Honor,
What is her age?
22 years old.
22? All right, so here's the thing. How would you like it if your daughter is out there driving, minding her business, not intoxicated, and you or someone like you comes along and ends up hitting her because you're drinking and driving?
Yes, Your Honor, I understand. It's terrible.
Yeah, so you cannot drink at all. And when you're on probation, you're not allowed to drink alcohol. Do you understand?
Yes, Your Honor.
And that GPS, you're only allowed to go to work, nowhere else. Do you understand?
Yes, Your Honor.
So if you're driving home and you're like, oh, let me stop at the HEB, it's on the way, that's a violation. Do you understand?
Yes, Your Honor.
All right, probation will go over conditions with you. Good luck.
Thanks, Judge.
Thank you.
All right, thank you.
All right, everyone, the court is going on recess. Anyone who has a plea agreement, I can take it up at during the trial. So you all can continue to confer. Everyone else, do not ask the court coordinator to say, oh, I can come back in
All right, let's talk about that. This hearing for Ativigan Leo was a textbook example of Judge Boyd, balancing serious accountability with a little bit of pragmatism to keep a defendant on the right track. Mr. Leo pled no contest to driving. While intoxicated third or more a third-degree felony carrying real consequences, and you could tell from the start that Judge Boyd was prepared to walk him step by step through exactly what those consequences meant, Mr. Leo was calm and polite throughout, answering every question clearly and never once sounding evasive. When asked if anyone had threatened or coerced him into pleading, he said no without hesitation, and he confirmed he understood the full range of punishment he was facing, up to 10 years in prison and a $10,000 fine. The state recommended a probated, sentenced 10 years, suspended for 8 years of community supervision, with some conditions that made clear this wasn't just a slap on the wrist. Those included 200 hours of community service, a 2-year driver's license suspension, an ignition interlock for half the term, 90 sober meetings in 90 days, a DWI education course, and a referral to felony drug court. The part that really showed Judge Boyd's practicality was when she offered Mr. Leo a choice between serving 10 days in the Bexar County Jail or wearing a GPS monitor for 30 days, partial for employment only. You could see she understood that losing his job as a quality engineering supervisor could quickly send the whole plan off the rails. So she found a way to hold him accountable without setting him up to fail. She also made it very clear that the GPS wasn't a license to do whatever he wanted. If he so much as stopped at the grocery store on the way home, it would count as a violation. Throughout, Judge Boyd never lost her steady, measured tone, but she also didn't shy away from making it personal. She asked Mr. Leo to think about how he'd feel if his own daughter were on the road and someone like him caused a crash. That moment wasn't about shaming him. It was about reminding him that these decisions ripple out far beyond just one arrest. By the time she wrapped up, you could tell Mr. Leo understood exactly what was at stake if he didn't comply. He agreed to all the conditions without argument and promised he'd follow the rules. The final instructions were precise: install the GPS by July 17th at 5 p.m., report regularly, show proof of employment within 30 days, and absolutely no drinking period. It was clear Judge Boyd believes that community supervision is a chance to get your life back on track, but only if you're willing to meet the court halfway. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,